Okay, good morning. So we're talking about legal and ethical considerations with psychiatric patients right now. And so first off, you had an advanced organizer that kind of had some terms and things on it. Did you have any questions about any of those terms? Voluntary versus involuntary commitment, patient rights, any of those things?
No.
Nope, no questions. Anybody else? I'm seeing a lot of heads shaking no. No? Okay. All right. So some of those I think are review from fundamentals, some of the, the basic terminology and stuff. So now what we're doing is we're applying it more to a psychiatric setting. So you're going to see that I'm not lecturing over every single piece that's in that chapter in the textbook, but trying to kind of make it a little bit more specific. So we know that ethics is the study of philosophical beliefs about what is considered right or wrong in society. And so there are some, kind of some ethical things that come up in mental health, but a lot of it really falls back on what is legal. So that's where we're going to spend most of our time today, okay? You'll have a little bit in the case study gets into a tiny bit of ethical type stuff, but for the most part, if you know the definitions of the different ethical terms, then you should be fine with the ethics piece. So when we talk about mental health laws, so there's a lot that has to do with admission and discharge procedures. And so a civil commitment, there are some terms that go along with that are legal in nature. So the writ of habeas corpus, or formal written order to free the person, basically that just means that that if somebody is detained or committed, that they have the ability to challenge that. So it isn't like it was a long time ago where somebody could get committed against their will to the hospital and then they didn't really have any recourse. There wasn't really a whole lot that they could do about it, and now that's law. Also, they have the least restrictive alternative doctrine, which means that the least restrictive measures should be used in a particular situation to achieve a specific purpose. Okay. So it means you can't take drastic means unless they're absolutely necessary for a specific purpose. Admission to the hospital. So this is important to understand that there has to be a reason, there has to be a justification to admit somebody to a psychiatric unit. And a well-defined psychiatric problem needs to be established. So they have to have some sort of psychiatric diagnosis. They have to be in an immediate crisis. So there has to be something going on at that particular moment, or other means are not available or they're not enough. So it means that basically that the person cannot be treated in an outpatient setting, that they require more than what's available there. And we have to have the belief, the reasonable expectation that the hospitalization is actually going to help the person. So just to give you an example of what we mean by this is that I've taken students to a group home setting. And in the group home setting, there were several patients there who had paranoid schizophrenia. And so they're at very different levels of what you would expect to see. And so one of the individuals there, she's extremely delusional all the time. Her baseline, she was on clozapine, which we know is reserved for those who are more resistant to other types of medications, right? So she's on one of the best medications that we have, and still she's extremely delusional. Her delusions were that she was microwaved, that there were microwaves I don't know exactly what she means by that, but that came down and caused her to have all these problems. She happened to have COPD because she smokes and believes that smoking is what helps her breathing. So, I mean, those are just her very fixed delusions. And to hospitalize her for that, for some people, that would immediately get them hospitalized. You know, they're not making any sense and they have these very strange delusions. She would go into all of these beliefs that she had. And yet that's her baseline. So there's no reason to hospitalize her. She doesn't meet the criteria for it. We don't think she's going to get any different. The other thing I can say is that we've had patients who are suicidal that are like that too, that their baseline is that they have some suicidality. What we look for is a lack of intent. So when they finally have a lack of intent, then they're discharged home. So you have to know your patients a little bit too. So voluntary admission is when a patient or guardian has the right to demand and obtain release. However, it isn't an immediate thing. So the patient or the guardian actually has to put in a written order, and it can take 72 hours for that order to, basically what it does is it gives the psychiatrist 72 hours to determine if that patient either needs to be committed through the court system or is safe enough to be discharged home. Okay. Involuntary admission is admission without consent, which means that the person must be considered a danger to self or others, need psychiatric treatment, or be unable to meet their own basic needs. Okay. And the need psychiatric treatment is really, it's part of it, but they have to meet the other criteria. They have to either be a danger to self or others, or be a danger to self because they can't meet their own basic needs. Okay, so danger to self or others is the big piece there. Also to understand is that even if somebody is committed, they are still, they still retain their rights unless they have a guardian that is saying otherwise. You know, as far as forcing medications and things, they still have the right to refuse treatment, even if unless they're court mandated to have certain medications or their guardian says they must have certain medications, they have the right to refuse. So what we often see, the one that we see the most is an emergency involuntary hospitalization. Some places will actually call that a pink slip, because the paper that they used to write this on was pink. It's a civil commitment. It's most places it is 72 hours. You'd have to know differences in your state, but generally it is a 72-hour evaluation. So they have 72 hours to evaluate the patient because they're danger to selves. Now the key here, there's 3 different types of people that can do this commitment. So one is a police officer. So a police officer can require somebody to be detained for up to 72 hours for evaluation. A physician, okay. Or the third one is another specifically appointed trained person. So let me explain that. A lot of times it's somebody with like a master's degree, at least in like a therapist or counselor or somebody, a social worker, something along those lines. And they work as like a pre-screener for a emergency evaluation place. So like in Toledo, the place that we work with was Rescue Crisis. And so what they would do is they have a trained individual that they call the pre-screener. And if we had somebody in the emergency room that was having a psychiatric emergency, that pre-screener would come in, determine if they met the criteria for a 72-hour hold, and then would call a psychiatrist and get that person placed, admitted to the hospital. So they still have to be in contact with the physician, but it was basically up to them in their assessment as to whether the person would be held or not. But I don't want you to think it's just any social worker, any counselor. It's not. It's those that their job gives them that authority. Another thing, just to, this is kind of on the side here, is note that those pre-screeners are often used. One, because a lot of places don't have, I mean, you don't have a psychiatrist there in the ER, but also because it's a conflict of interest to admit for the ER physician. Let's say you have an ER with a psychiatric unit. So let's say like Flower Hospital. It would be a conflict of interest for the physician to mandate somebody be admitted to their hospital for at least 72 hours. Does that make sense? So if you have that third party come in and be the one that evaluates, then if their insurance covers that hospital, they go there. If their insurance covers a different facility, they would go to that other facility. Okay. So long-term or formal commitment can be 60 to 180 days, and that's from the result of a judicial hearing. And so somebody is formally committed for psychiatric treatment. And I have taken care of patients who have been formally committed to even Flower Hospital. So a lot of times it's to like the state hospital, but not always. Involuntary outpatient commitment, I've really not seen this. I imagine it happens more at like your state hospitals and things, but it mandates that care is tied to services like housing or disability services. And if the person doesn't comply with the mandated treatments, then it's a swifter, it's an easier process to get them hospitalized. So it would just be more of a clean, like you're not doing treatment, you're going into the hospital. Discharge from the hospital. So most, there's a conditional release, which is somewhat similar to an involuntary outpatient commitment. Again, these are not things that I have personally worked with, but it would basically mean that if they don't, they're doing like trials at home, and if they don't comply, then they get rehospitalized. Most of what we see is an unconditional release. It's just discharged from the hospital like you would anybody else. Now, what I don't often see but can happen on a psychiatric unit is a release against medical advice. And that's where the belief is that they would really benefit from hospitalization, and the psychiatrist really does not want to discharge them, but they don't meet the criteria anymore. They're not, to be held against their will. They're not a danger to themselves. They're not a danger to others. They're taking care of their own basic needs. So when we look at patients' rights under the law, most of the time patients' rights, psychiatric patients' rights, are not any different than anybody else's. So they have a right to treatment. They have a right to a humane environment. They have a right to staff that is qualified to treat them. And they have to have an individualized plan of care. That's not any different than anybody else. They also have a right to refuse treatment most of the time. Okay. And here's where it starts to get a little bit sticky. So it's debated, and it's tied to somebody's competency. So if you remember from fundamentals, there's a difference between capacity, which is when somebody, that's a short-term thing. Like any of us could lose capacity to make decisions because we were under anesthesia, okay? But competence is deemed by the court. So that is a legal term. Somebody is either competent or declared incompetent by the court. And if somebody is declared incompetent, then they're given a guardian, assigned a guardian, and then that guardian is the one who makes the decisions about treatments. So they don't always have the right to refuse treatment. The other time that a patient, and this isn't just a psychiatric patient, but it's any patient, doesn't have the right to refuse treatment if they're in immediate danger to self or others. So somebody can be put in seclusion, put in restraints. They can be chemically restrained, given medication that sedates them, okay? And those are all things that are done against somebody's will. The right to informed consent. So the patient does have that right to informed consent for any of the medications that they're taking. It should explain the risks, the benefits, their options. And what's really interesting is that psych often does this very well. The patients actually at Flower, they would sign a paper for each medication that they take that says that they received information on each one, and risk, benefits, side effects, all of those things. So as I stated, patients are legally competent until declared incompetent. And so that competency means that they have the capacity to understand the consequences of one's decisions. So it's the capacity to understand the consequences of one's decisions. And then, as I mentioned, if they're incompetent, they get a guardian, and it's a judicial decision. Okay. So there are rights surrounding involuntary commitment and psychiatric advance directives. And so unfortunately, what we see here, we don't see very many psychiatric advance directives. However, these would be extremely helpful if we could do this. The number of times that I've admitted patients who are incoherent, illogical, they can't tell you what family they want, they can barely make up their own code word, let alone call family members and give them the code word so they can, get information about the patient. So if these patients had a psychiatric advance directive, it would document the patient's choices. It would let us know who could visit, who could be given their code words. It would let us know which medications or treatments they would be okay with versus ones they're not. But for those patients who are extremely ill, it would make a huge, huge difference. I don't know why we don't push these, but for some reason we don't. I would like to see that change. So when we talk about rights regarding restraint and seclusion, unfortunately, restraints and seclusion used to be used as a form of punishment for patients. And now we use it as an absolute last resort. So after verbal de-escalation has failed or medications have not worked, and the behavior is significantly bad that they are really a danger to themselves or others, that's when we resort to seclusion or restraints. So a couple of things to keep in mind is that a nurse can make the decision to put somebody in seclusion or restraints and then call and get the order. And when somebody is acting out, it can be really difficult. Unless the psychiatrist is there on the unit, you usually don't get the order until afterwards. When somebody is in behavioral restraints or seclusion, they do require that the patient is a one-to-one for the first hour. So what that means is when somebody's in seclusion, somebody actually has to stand at the door and watch them. Okay, so a one-to-one, they're not within arm's reach because there's a door between them, but they actually have to stand at the door and watch them. And then after that, they can be camera monitored. So somebody sits there and watches them on camera the whole time, documenting every 15 minutes. If the patient is in restraints, then they're a one-to-one the whole time. So somebody's there within arm's reach of that patient at all times, documenting patient needs, that they're meeting patient needs every 15 minutes. The patient in seclusion or restraints gets a physical assessment every 2 hours. Now, this can be a little weird. when your patient is in seclusion. But basically, you're looking at them to see that, skin's intact, they're not injuring themselves, their breathing is non-labored. You're just trying to make sure that things look okay, that the patient looks okay. Generally, these are ordered every 4 hours, although some of that is determined by facility and by the state, but usually it's every 4 hours. You have to have a reorder. They have to have a face-to-face with a physician within the first hour and then every 24 hours after that. Now, I will tell you, a lot of times the hospitalist does not like to do that first one, especially if they're in seclusion. I've gotten yelled at a few times about how are they supposed to do an assessment on someone who is in a locked room, behind a door. And I just tell them it's the same way I'm doing it. You have to just document what you see, and everybody knows that the patient's in a seclusion room, that you're not actually listening to their lungs and stuff. You're just documenting what you can. And it's a legal requirement, so they have to do it. So those have been a few fun times in the middle of the night. Okay, so what we have to think about here are some of the criteria for those seclusion or restraints. So the behavior is physically harmful to the patient or another person. When nothing else worked to protect the patient or others from harm. When the patient needs a decrease in sensory overstimulation, I personally have never really used a seclusion for that, but I've used the seclusion room for that and just not lock the door. Just let the patient in there to kind of calm down, but that's not considered seclusion unless we lock it, as long as the patient can get out. When the patient anticipates that a controlled environment would be helpful and requests seclusion. I have never had a patient request seclusion. So if you ever do, that's great. You can put them in there, it's legal, but I've never had anybody ever ask me for that. We must have a written order from the physician. They do have to be time limited, so that's why we have, the reorders every 4 hours. I think for children, the reorder is even less than that. It might be like every 2 hours for children, but I've not worked with children in a psychiatric setting. When the patient's condition is reviewed and documented regularly, and as I mentioned, you have to do physical assessment every 2 hours. So you're removing restraints, you're doing range of motion. You are like one restraint. You would, if the patient is compliant enough, you could remove that one restraint, do range of motion, check everything in that extremity and move on to the different extremities. If they're not, then you just, again, you do what you can. And then when the original order is extended after review and reauthorization and specify the type of restraint. So every time that they're put in restraints, we have to have that they're, 4-point leather restraints, behavioral restraints. Then after that, it's reauthorized. So I'll tell you a story here in a few minutes, but please understand that, as I mentioned, restraints are always the last option. It is difficult to have somebody in restraints. It is not fun at all. It's extremely draining to have somebody in restraints, emotionally and physically, and the things you have to go through to get to that point. And then, of course, the documentation that you have to do. So that 15-minute documentation is so important, so that whoever's doing that one-to-one is writing that they can see what the patient is doing, what they've offered, if they offered fluids, a bedpan, a urinal, any of those types of things are all, documented. Okay, we're going to move on a little bit, and then, like I said, towards the end here, I'll tell you a few more examples. So the maintenance of patient confidentiality is extremely important in mental health. People do get fired over breaching confidentiality. It's a big deal, more than it is anywhere else. So there are some exceptions to the rule, though, and these are extremely important to understand, that we have a duty to warn. So if there is criteria for a duty to warn, then we have to ensure that that takes place as part of the healthcare team. So what this means is that we need to make sure that the treatment team is aware of any threatening statement made against a third party. Now, it would have to be a specific third party. It can't just be a general cultural issue, like saying that they want to hurt all the white people or, whatever. It has to be like specific small group of people or a specific individual. And that would indicate then that we have a duty to warn. So if somebody says, I'm going to kill my husband when I get out of here, then as the nurse, they tell you that information. It has to be documented in the chart. And then we would let our treatment team know that this was stated. And then very likely what would happen is social work would have to call that person's husband and let them know that there were threatening marks made against them, and they could file a police report and things as needed. And if there needed to be protection orders, all that would be determined, with the police and the judicial system. But if we hear those remarks and we don't ensure that something happens from that, even if it was, maybe we thought it was a flippant remark, and so we talked to the treatment team, we would need to ensure that that the psychiatrist, everybody was in agreement that that was a flippant remark, that the severity of it doesn't meet the criteria for a duty to warn, stuff like that. So it's not an individual decision, but it is important. We are part of that, and we can be held responsible if it doesn't happen. Are there any questions about that? Because that's a really important piece, what a duty to warn is. Are we good? Yeah, okay. So duty to protect, this means that the nurse has to take steps to protect others. So that means the other patients that are in your care, you have a duty to protect them. So we need to keep that in mind, that, we have to make sure that they're okay. Now, the nursing implications are pretty much what I already mentioned, that we may not be the one that is directly relaying the duty to warn, but we're part of that treatment team decisions. And that if we had information and did not pass it along, then we could be held responsible for that. The next little tidbit I have here is child and elder abuse reporting status. I think we all know by now that we are mandated reporters for child or elder abuse, as well as protected individuals, which some of our mental health patients who are chronically mentally ill or have intellectual disability would be considered those vulnerable populations that we have a duty to report if we thought that they were being abused or neglected, anything along those lines. You'll talk about child abuse in pediatrics, and we've talked a little bit about older adult abuse in fundamentals. So just a reminder that we're mandated reporters for that as well. Tort law applied to psychiatric settings. So basically, this is just kind of going over some of those definitions. So a tort is a civil wrong for which money damages can be collected by the plaintiff from the defendant. And so there are some intentional torts that can be that are more commonly expressed in mental health patients. Let's say that. So battery, assault. So assault's usually verbal, right? Battery is usually physical. And false imprisonment. So I cannot tell you the number of times I've been accused of false imprisonment simply because the patient is on a locked psychiatric unit and they don't want to be there. But if you put somebody into restraints or into seclusion and they don't meet the criteria for it, you can be in trouble for false imprisonment. Or if they are beyond their 72-hour evaluation and they don't meet the criteria, we need to be talking to that psychiatrist, because we could all get in trouble for false imprisonment for that. As well as, you have to watch how you phrase things for assault. If I said, if you don't calm down right now, I'm going to give you a shot. That's very different than if I say, your behaviors are getting, out of control. We need to work on controlling those, or I'm going to have to give you some medication to help you control those behaviors. So one's threatening and one's not. And then, of course, battery, when we hold patients down, we have to be really careful that they meet the criteria to be held down and given an injection, or held down and put in restraints. So our documentation is extremely important. It has to be very clear about what is happening, why, what we tried, even the number of people. So if we have multiple, like 5 or 6 people, we have security, and it takes that many people to do it, like a takedown is what we call it, to give somebody medication or put them in seclusion or restraints, then we document the number of people that it took. So that way everything is crystal clear in that documentation as to what happened and why. So common liability issues, protection of patients. Overall, nurses must take measures to keep patients safe. Overall, nurses must take measures to keep patients safe and advocate for them. So we have to do that. And then the last statement I have here is about violence, and we'll actually talk about that a little bit more, I think, next week. We know that violence can take place in any setting. It doesn't have to be a psychiatric unit. In fact, ERs are probably just as common, if not more common, for violence to take place. In a psychiatric unit, though, we are trained, the staff is all trained in nonviolent crisis intervention. And so these are ways to protect ourselves, as well as ways to take a patient down without hurting them, or to make somebody walk with you. So you have 2 people, one on each side of the person, and there's a way to kind of hold their arms and kind of force their legs so that they have to walk to where you need them to go. So there's certain things that we do to try to protect ourselves, and training that we go through so that we can protect the patients too, so they're not getting injured unnecessarily. Some things that you have to keep in mind is that you have to protect yourself. You're the one that's in charge of protecting the patients, yes, but if you're not safe, then nobody else is going to be safe either. So it's vitally important that you do protect yourself. And that know that there are times when you get in over your head, or things that are happening are too much, and you have to call law enforcement. So I have seen law enforcement go on to the psychiatric units before, only a few times, and there's a couple other times that I've heard of where law enforcement has had to go on to the units. They don't usually like that, because they generally have to lock their gun and taser up. They're not allowed to have those on the units. So they don't always like coming onto the units, but sometimes it is important. I'm going to stop recording. I'm going to tell you guys some